This is the first morning of our December call. We're going to call our first case, which is Bowerman versus Red Oak Management Company Incorporated. This is a mini oral argument on the application. There are 20 minutes per side, and I believe for appellees you're going to divide your time, correct? So you may begin. Mr. Desmond, you have 2 minutes, fire-free zone. If you want to reserve any time for rebuttal.
Thanks, Chief Justice. I'm planning on 4 minutes. I know that's kind of my responsibility, and I'm historically awful at doing it, so we'll see what happens.
But we don't help much.
So, good morning, Your Honors. Christopher Patrick Desmond from Venn Johnson Law on behalf of the plaintiff, Jan Bowerman. I'm joined at counsel's table today by my associate, Tom Carr, who is instrumental in the briefing today as well as the preparation for this argument. Of course, ordinarily, Mr. Johnson would be here. He's delivering closing arguments, I believe, today in Genesee County, which is why he's not available. The only thing that I'd like to say before I invite questions from the panel is that I think that each of the issues that the court has asked for a supplemental briefing on today is deserving of an opinion from this court. And I mean that without regard to whether my client ultimately prevails or not. The reason why I say that is because I think each of the issues that are before this court are areas where this court hasn't weighed in on the law recently, and where our lower courts have really demonstrated a confusion around the analytical framework that should apply. And so I think that the bench and the bar could really benefit from this court's insight regarding each of these issues. With that said, I welcome any questions from the panel at any time. I think I will begin with what is identified as issue 1 in our briefing, which is the liability of defendant Westveld. So below, it's actually one of the interesting aspects of this case is that I don't think the parties completely agree on what the Court of Appeals.
Good morning. Just a quick question, and I think you're going to probably get there, but I just figured I might as well ask it. When does Westveld's responsibility conclude?
So, Your Honor, I would say that Westveld's responsibility concludes when the dangers that they created through their work are no longer creating a hazard for the residents of this facility. And so I don't think that there's a concrete answer, in other words, to that question. I don't think that there's a particular date. What we know here is that they finished their work on October 21st, and my client falls on October 30th. The trench into which she fell is in the exact same condition on October 30th as it was on October 21st when Westveld left. Meaning, there's no changes that have happened since Westveld left that would make this unfair or inequitable to Westveld to hold them liable for the condition they created.
Thank you.
You're welcome. So the Court of Appeals, Your Honors, essentially concluded that under the Fanazzo case, it recognized that under Fanazzo, under Clark v. Dahlman, under Lewecki, there's a long line of jurisprudence from this court indicating that if you are performing some task pursuant to a contract, you have an obligation under the common law to perform that task with reasonable care so as to avoid creating unreasonable dangers that can harm individuals like Ms. Bowerman. The Court of Appeals recognized that despite the urging of defense counsel to apply a different analytical framework, but it made the factual finding itself. It said no reasonable jury could find that Westveld breached that duty under these facts, and I simply don't see how that conclusion can be supported by this record, where we know that Randy Westveld and Eric Cook, who's essentially the property manager for defendant Red Oak, who was in charge of overseeing all of these construction projects at Red Oak's various properties, they both testified that this trench amounted to a trip hazard. This, of course, is a facility that is reserved exclusively for the elderly and the disabled, and Mr. Westveld has had direct exposure to that fact during the course of his work. He explains how he's got these trenches that are spread throughout this complex, and on one occasion he sees a disabled individual who's trying to navigate over one of these trenches with a wheelchair. And so he goes and he takes the step of filling in that particular trench with sand or asphalt millings in order to create a level surface for that resident. Well, Ms. Bowerman didn't have the benefit of that kind of courtesy. And so there's an acknowledgement that this trench was left open and that it was left unguarded. I want to acknowledge that for a second, too, because I think that there was some confusion in the Court of Appeals regarding that point. there's a photograph in this record that shows the trench at issue, and it shows some tape surrounding the perimeter of the trench. That photo was taken after the events at issue in this case, and so that doesn't represent the condition that Randy Westfeld left this trench in when he completed his work. So where we know that everybody recognized the danger posed by this trench, the special nature or aspect of the facility that this work was being completed in, and the fact that the trench was exposed, I think that there's a genuine issue of material fact for a finder of fact here regarding the reasonableness of Westfeld's conduct.
Counsel, could you speak to what we're supposed to look at, the condition of the parking lot versus sort of the location of the dumpster / trench?
Sure. So Your Honor, I think that probably goes a little bit more to the second issue, which is the statutory issue under MCL 554.139. You know, I think that that's an exercise for this court, right, in terms of defining what the common area at issue is. That's what the statute talks about. The statute talks about keeping the premises and the common area fit for the use intended by the parties. There was, of course, no analysis in this case of what the use intended by these parties was. But I would say that the common area at issue is the trash disposal area and everything that makes up the trash disposal area, which I would submit is the sidewalk that leads to this dumpster area, the dumpster area as well, the pad that the dumpster sits on, and frankly, on this occasion, probably a portion of that parking lot because of the construction work that was being done that was essentially funneling residents into other areas when they were trying to dispose of their trash. So I think we have to take an expansive view of that, Your Honor, and the reason why I do think we have to do that is because of that language of, you know, the use intended by the parties. So Allison, you know, Allison versus AEW Capital is, of course, the sort of seminal case from this court on this statute. Allison simply analyzes it as a parking lot in that case because that's what it was. There was an individual who was trying to get to their car in order to be able to leave their facility that day. The Court of Appeals in this case kind of does the same thing. It says, well, we've already talked about parking lots before. In Allison, we talked about parking lots. And we talked about how you just can't, if there's a mere inconvenience of access to a parking lot, the statute isn't implicated. Well, that's not what this is. Ms. Bowerman wasn't trying to drive anywhere that day. She was simply trying to throw out her trash, and she had no way to get to that dumpster area without navigating through these hazardous conditions.
So we're not having to disagree with Allison. It would just be more of an application based on what do we look at? Allison understood it was about the parking lot in particular.
Right. So to the extent the question is kind of hinting at, do we need to overrule Allison for my client to win? I don't think we do, but I think this court should. I think that at a minimum, Allison needs to be clarified significantly. And that's because of what Allison's progeny shows this court. Allison uses this phrase at one portion during its analysis where it talks about mere inconvenience of access. It is very, very clear to me when I read through that opinion again and again and again in preparation for this. When the court's talking about mere inconvenience of access, it was talking about the plaintiff's, the inconvenience of the access to the plaintiff's car. It wasn't talking about the common area. It wasn't setting up some sort of rule for future courts about the convenience of the access to a common area. But that is precisely what every single court has run with since Allison came out. There is, I think, a glaring, I don't know if it's an error, but it's an oversight in Allison that I think certainly needs to be addressed. And that's the complete silence from this court regarding MCL 554.139 subpart 3. So Allison is endeavoring to interpret this landlord-tenant statute. And of course, it's doing so in a time when this court was making it very clear that we're supposed to be driven by legislative intent. What did the legislature intend these words to mean? Well, 554.139 sub 3 is really interesting because it specifically directs this court and all of our lower courts. It says the terms of this statute shall be liberally construed. And so this court in Allison is trying to construe that statute and say, what did the legislature mean? Yet it never once references that. And so what we've gotten to is a statute that didn't exist, right? We all know how the legislative process works, and it's thorough and it's complicated. The legislature takes its time to pass this statute to give a remedy to residents of the state of Michigan, and takes the rare step of saying, and you need to liberally construe this statute. What we've been left with is a increasingly narrowing remedy to the residents of Michigan based on the words in Allison. And so I don't think this court necessarily has to go as far as saying Allison was wrongly decided. You know, one of the other cases that's come up in reference to issue 1 of this case is maybe a little bit reminiscent of what's happened with Allison. That's the Fultz case. So this court came out with the opinion in Fultz, and then Fultz kind of was misused by lower courts for a series of years until Loecki came out. Loecki didn't overrule Fultz, but it clarified it, and it mostly corrected the ship, right? Now, this case shows that there are still some issues with that potentially. But I think it's similar with Allison. I don't think that the error is necessarily in Allison itself, but it's what Allison has turned into over the 17, 18 years since this court issued that decision.
Counselor, you emphasized that the residence here was meant for elderly and disabled individuals. And
Yes.
do you have any authority for the idea that we would interpret the statute in light of the particular user, or that it's a more objective standard? Does that matter?
Yeah, absolutely, and it was completely overlooked in the Court of Appeals. If the statute says that the common areas have to be fit for the use intended by the parties, we can't throw a broad blanket over all parking lots and say this is the intent of this parking lot. A college freshman who's living at Michigan State University, right, and ignore the governmental aspect of it. College freshman who's walking through the parking lot at Case Hall, the parking lot could have a crack in it, and they say that doesn't affect me at all. But a resident who moves to a facility because they're elderly or disabled, they know they may have some balance issues, some mobility issues. They know that a fall could be devastating to them. They need to make sure that that facility is going to be proper for them. Otherwise, why would facilities advertise themselves and present themselves as, we are a facility for the elderly and disabled? It's to send a message to those communities that we understand the needs that you have, and we're going to adapt to those needs and take care of those needs. And I think that's precisely what the legislature was trying to do in that statute. It recognizes that the legislature, in a way, is dipping its toes into contract with this statutory authority. And contracts, of course, are a very personal, individualized thing. And so you have to understand what the intent of those parties were that were entering into that contract when you interpret this statute. That didn't occur here, but you know, I don't mean to be flippant about this, but I do think that this is a fact that just jumps off of these pages to me. You know, we have an elderly woman who is painstakingly taking notes in her diary every day about what does the facility look like today? Where are the trenches? Have they put up tape? Have they not put up tape? She's trying to take out her garbage, and she's trying to do it as carefully as she can to avoid this injury. Yet she ends up army crawling, a 75-year-old woman army crawling from a dumpster with a fractured leg back to her apartment, and then she spends the next year not mobile as a result of the condition of this property. And so it certainly isn't what she was endeavoring to enter into when she entered into this lease, Your Honor.
Can I follow up on that?
Yes.
That question of what the parties intended, I recognize the argument that you're making regarding the statutory language that's used. Does that need to be evidenced or buttressed by, in fact, the contract? By the lease that would specify that this is, you know, as opposed to just maybe, like you're saying, advertising, or they knew that, you know, most people who live there were disabled or elderly. Like, is in order for that language to be implicated from the statute, does it need to be tied to the actual lease?
I don't think it necessarily does, Your Honor. I think that sometimes, you know, well, oftentimes I don't think intent is laid out within the four corners of the document. We typically, when we're interpreting contracts, we try to derive intent from the plain language of the statute, right? In terms of, not necessarily the contract says this is what the intent was, but we can read into what the intent of the parties were by the nature of the instrument they entered into. I could see that question being a bigger problem in other cases, and I understand this court has to think about the big picture in crafting a rule. In this case, when we're simply talking about an ability to safely walk to the dumpster when you're an elderly person and they know you're an elderly person, I don't think we have that concern here.
Well, how would, if we were to write an opinion along those lines, saying that the statute requires us to look at the use intended by the parties, what would we cite to in support of that to say that these parties intended, like, that the use was for disabled and elderly people?
Well, so in this case specifically, I think we would point to the nature of Stanton Park Apartments, and that Stanton Park literally reserves itself for people who, I think it's over the age of 65 or someone with a disability. And
In
so,
its advertising.
I believe it's in its advertising materials. I don't think there is any eligibility for anybody to live there unless you fall into that criteria. That hasn't really been a major aspect of the development of this record because it's always just been accepted. You have to be disabled or elderly to live there. And so everybody in this case understood that this is who this community is for. And so I think in this case, it's understood, it's not really disputed that everyone understood this is who this facility was for. In future cases, in terms of what the rule looks like, I think it's simply an aspect of the intent of the parties, like in any contract, where sometimes in an individual case you're going to see it on the document, sometimes you might have to go to extrinsic evidence if there's ambiguities in the contractual language. It's just going to be a case-by-case contract analysis.
So if you had an apartment building that had college freshmen and elderly and disabled, there was no sort of special, but even if the landlord knew that some of its tenants had mobility issues, how do we determine the use intended by the parties?
So I think in this instance, it wouldn't matter. I think there are some cases where it could. There are some cases where you could say, well, this common area was completely fit for what the general intended use was of the residents of this facility. In this particular case, though, I don't think that there's any facility where we can say a trash disposal area can contain 10-foot long, 5-inch deep trenches. That represents a hazard to everybody. And that's what the testimony in this case is, right? When Randy Westfeld testifies and Eric Cook testifies, they testify that trench is a trip hazard, and it's not specific to my client or the class of client that we have in this case. I don't know if that answers the court's question.
It does.
Counsel, I'm wondering, and I know we're cutting into your rebuttal time.
That's okay.
But this is something I would ask you.
Yeah.
I anticipate that opposing counsel is going to talk about avoidability is a key consideration under 554-139. I was wondering if you could address that.
Yeah, I don't like that argument just as well, and I'll tell you why. This statute was always seen as being, it's weird because open and obvious is kind of the thing that is hovering over this case in a way. Open and obvious, of course, has been dramatically reworked by this court through Kandil El Sayed and the overturning of the Lugo case. But prior to those events happening, this statute was always almost seen as like a safe haven for residents of facilities where it's open and obvious doesn't permeate this area of law, because open and obvious specifically went to the duty aspect of a cause of action. And you don't need to worry about the duty aspect if you have a statutory duty. So once the legislature imposes the statutory duty through the passage of MCL 554.139, plaintiffs aren't supposed to have to worry about the open and obvious aspect. Now, comparative fault is obviously, of course, always a thing, but there was a small order from this court, I believe it was about a year ago, in a case called Holder, which Chief Justice Kavanaugh, you wrote a dissent saying, I would grant leave in this case, and Justice Welch, you joined that statement. And in that case, this would maybe ring a bell because I think it's a pretty unique fact. There were algified stairs at an apartment complex, and the client is trying to walk down them, and she successfully navigated these stairs plenty of times. The algae didn't pop up overnight, and she falls, and the court basically says, well, you've avoided it before. They invoke this concept of avoidability, and Chief Justice Kavanaugh, what you said was, the fact that someone can avoid something doesn't obviate the statutory duty that our legislature imposed on landlords. And so I think it certainly presents an opportunity for them to make a comparative fault argument if they want to. But I don't think that it can in any way take away what the legislature imposed on landlords in every single residential lease that exists inside of this state.
So again, with the shift from open and obvious being a duty question to now more properly, considered a breach question, even though it is not relevant avoidability to the duty imposed by the statute, is it relevant to whether or not it was fit for the use, right? Is it not relevant if somebody can avoid it, that it is reasonably fit?
Certainly. I think it's certainly relevant. I think these are all the things that would be told to a finder of fact during the course of a trial, and it'd be all the things for a jury to consider, because reasonableness, I think that's the thing about this statute that's jumping out to me, because I've been thinking that same question, Chief Justice, like, well, who does that, and how do you determine when something crosses that line from being fit to unfit? But we ask juries to do it all the time when we talk about reasonableness. When did someone's conduct cross the line from being reasonable to unreasonable? And so these are the assessments that our communities make by considering the individualized factors in any given case. Things like age and nature and darkness, right? Because we have a facility here where not only do you have trenches, but you have darkness corresponding with those trenches that are dug into black asphalt. And so there's very limited visibility here, which is supported by our expert testimony. So I think in totality, we have a classic fact question for a jury on both issues 1 and 2.
Thank you.
Thank you very much, Your Honors. I apologize, I won't be able to talk to you again in a few minutes.
Good morning, Your Honors. I'm Dan James. I'm the attorney for the defendant, Red Oak Management Company. May it please the court, I intend to try and leave 10 minutes for the attorney for Westfeld Services. Because I have less time, if you have questions, I would rather spend time answering those questions than giving you my speech. But I think what we need to focus on in this case, and my issue, of course, is the statutory claim under 554.139, is that's the only claim in this case against my client. There's no tort claim. There's no common law premises liability claim. So we really need to take off or stay focused on the fact that this is a contract claim, which is what Allison says this court is. And the way we interpret contracts is by giving them their plain meaning, and that's what Allison did. And the terms that they've honed in on there were, for subsection 1A, a common area. The parking lot, the sidewalks, no question it's a common area. I don't think we need to slice and dice it into the part over by the dumpster or the part over here. It's the parking lot, it's all of it. That allows people to access in and out of the building. And as far as parking lots go, ability to access their cars, get to them. And also, I don't dispute in this case, given where the dumpster was, an intended use was going across the parking lot or taking the route down the sidewalk and across the cement pad to the dumpster.
So is it your view, counsel, that if you have to cross the parking lot or access the parking lot to get to a different section, it's always just the parking lot we look at? We don't look at the perimeter or what's going on the outside of the parking lot?
Well, I suppose in certain cases you could, but the question in the case at hand is, was the common area at issue fit for its intended purpose? And here, Ms. Bowerman testified at her deposition that the only thing she was concerned about in the parking lot was this specific area in front of the pad where she tripped. And I think that's because even though there had been a lot of work going on, they were in the process of improving the sidewalks, and the sidewalks had been repoured. The cement pad where the dumpster was had been repoured. That was all brand new. And there were still some trenches, and as counsel indicated, a lot of them had been filled in with millings, but unfortunately this one in front had not. So to your question, though, I think you have to look at the whole parking lot because it's one solid surface. So then the question is, intended use, and I touched on that, but also fit. And so fitness, Allison, consistent with contract principles, goes to the dictionary. And they see that it means suitable, adapted, appropriate. Now, fit is a different standard than reasonableness. Reasonableness is a tort question. And I think the reason why courts have been more inclined to grant summary disposition in these cases is because it's a much more specific standard. Is it fit? Can people do what this common area is intended to do? Can they access their cars? Can they get to the dumpster? Can they use the sidewalk to get in and out of their apartment? And so it's a lower standard. The duty of fitness, Allison notes, is even lower than the duty of repair that's in subsection 1B. So it's a lower standard, it's a more specific standard, and that's why courts have been able to look at facts of cases and make determinations as a matter of law whether there was a breach. I think that the jurisprudence for this statute would, of course, look so much different if we had never had the open and obvious doctrine. People would not have relied upon this statute if the open and obvious doctrine hadn't precluded a lot of tort claims. In fact, now that the court has reworked that open and obvious doctrine and basically got rid of it in the sense that it no longer defeats a tort duty, I get premises cases at apartments now that don't even have statutory claims because they don't need it. They have the tort claim. Open and obvious isn't a barrier. They don't gain anything by adding in a second count for a statutory claim that has a much stricter, or I should say lower level of care that's required. And here's the other thing. With the statute, the focus is on the common area. It's not on the defective condition itself. There's no question in this case that this trench was a trip hazard. If this was a tort case we were here before you on, the whole focus would be, is this a dangerous condition? Is it a trip hazard? That's not the full focus when you're analyzing cases.
Is there any factual scenario in which you would agree that this trench would be unfit for the use? Say it's filled with like snapping turtles.
Right, well, so I was thinking, okay, so I mean, I'm going back to Lugo and, like a 30-foot pit or something like that.
This is the problem. We keep going back to open
Well,
and
but
obvious
I guess
doctrine.
my point, though, is that if this was more dangerous, like what Lugo was thinking when they were talking about unreasonably dangerous, I think you could get to a point where a condition was so dangerous that it on its own might have rendered a common area unfit. And in that regard, Your Honor, a lot of these cases, and with the little time I have left, I'd like to just kind of walk through sort of the patterns we have. We have cases where people step in a depression, and I cited one of those, or there's a height differential in a sidewalk. The key considerations in those cases are, was it avoidable? Did it deny access for the intended use? And in this case, this was one small relative to the size of the common area, but defect that was able to be avoided in an infinite number of paths as long as you just walked around it, no matter where you approached the dumpster from.
Why isn't avoidability a question for the jury, as counsel suggests? Or avoidability relative to the fitness as well as plaintiff's comparative fault? Why isn't that a question for the jury to determine? You might be right, and a jury might agree with you, but why isn't it a jury?
I don't think, given the facts that we have in this case, that even Ms. Bowerman herself had gone out into the parking lot, took her trash out every day, and had successfully avoided this area multiple times, as well as all the other residents of the place. I think that's really, really compelling evidence that this was avoidable. And it's also consistent with common sense that this is an open parking lot, and there's a trench in a specific spot that's known by everybody to be there, and everybody can just walk around it. Now, to change gears, the cases where courts have had
Well,
problems.
there wasn't
Yep.
any signs or cones or anything to indicate that this was taking place, was there?
Well, when the work was being done, but not at the time of the incident, no,
Right.
Your Honor. Correct.
And counsel, as to avoidability, it sounds awfully similar to comparative fault. So why isn't it not just a question for the jury?
Well, because again, it's a contract claim. The question is whether it's fit. And things, even comparative fault, though, doesn't have to be a question for the jury. And the mere fact that in all these cases, the person was unable to avoid it for whatever reason, and the courts have held that summary disposition was still appropriate, just because one time doesn't render this otherwise fit parking lot unfit. And the cases where the courts have held that there's questions of fact are where the condition is widespread. Cases where algified stairs, and I know that I actually think the Court of Appeals got that one wrong, because if the stairs are completely covered, it's unfit.
So the
It doesn't-
fact that, is it your position that you have a whole parking lot that is just fine to park cars and come in and out, but it has, by your acknowledgement, a hazard in a portion of it that actually causes injury, then what's the guiding criteria of when, does it have to be big enough? Does it have to be deep enough, to decide that the parking lot is fit? And is that only sustainable if we agree with your position that we have to look at the entire parking lot as opposed to the actual trash disposal area?
Well, again, with it being, so the mere inconvenience language, basically what I think the Allison court was saying was, look, just because you may have to take a step to the side to get to your car to go around it, doesn't mean that the parking lot's unfit. But in the cases of the stairs, whether they're covered in algae or they're covered in ice and snow, they deny complete access. And in my opinion, it doesn't matter then that the plaintiff knows they're icy or covered in algae, or that she had managed to safely do it before and maybe got lucky a few times.
Doesn't that sound like the special aspects creeping into this fitness question? The old
Sure.
special aspects effectively unavoidable?
I think we have a contract claim, we're interpreting the word fit, and yes, there may be overlap in some of those considerations, but I think we really have to try and ignore all of that because it's just not, in my opinion, applicable.
I just don't want
Yeah.
to eat too much into
The last-
council's time.
If I may, the last thing I wanted to say was about the elderly and the disabled. Because
Does that factor into this?
I don't think that it's irrelevant, but I think in this case, it doesn't change the outcome because just recently there was a Court of Appeals case, unpublished, Cream was the plaintiff. This argument was raised and the court said, look, that by itself is not enough. I don't think it automatically creates a question of fact because the residents here are elderly or disabled. I think there would need to be some factual connection to show that their age or their disability somehow played a role. And I don't know that there's any evidence of that in this case. So thank you very much.
Thank you. Ms. Turner.
Good morning. May it please the court, Charlene Turner on behalf of the defendant Appellee Westfield Services, LLC. Given how this has gone, I'm not going to reserve time for rebuttal. I'll just continue on. So, as the court knows, the question specifically directed to Westfield was whether a genuine issue of material fact exists as to the defendant Westfield breached a duty owed to plaintiff. Now, again, I believe it's a little unusual for this court to focus on a factual-centric question, as I believe this case lacks jurisprudential significance. I don't know that there's any evidence that cases have been inconsistently applied, such as
Counsel, good
Hill
morning.
or...
I just have a quick question. Does it matter that the site was left without any kind of signage, any type of warning? I mean, is that something that is appropriate, or is that something that's done in the industry where they just came, I understand they were waiting for Bob's asphalt, but is the notion that they just came, they did their job, and then they left a site that has some danger, is that acceptable kind of in the workplace for this?
So I'm glad that you asked that question. So first of all, I think it's an important distinction that this was not a contractor on the construction site when the incident occurred, okay? So then the common law duty owed by a contractor is to engage in the performance of an undertaking to use due care or not to unreasonably endanger persons or property. Important, as Hill explicitly clarifies, this duty does not obligate one person to aid or protect one another. And also, there's no common law duty that this extends. Of course, that can be extended by the parties by contract. And I agreed with counsel here, contracts are individual and personalized in nature. But here you have no evidence that Red Oak and Westfield contracted for continuing duty to go above and beyond when they were on site.
Well, so let me just, I'm struggling with it, because what I think Fultz, Lewicki, and Hill indicate is that somebody who undertakes a contractual obligation can't do three things, right? You can't actively harm somebody in the performance of that. You know, they couldn't run over her with a machinery. You can't make an existing hazard worse. And you can't create a new hazard. And why is this trench not a new hazard, even after you've left? Why does your client absolve itself from liability by creating a new hazard but then leaving?
So those are things I don't believe are met factually because no Westfield representative was on site. As to your question, as to the hazard, Westfield, the record is clear. Westfield completed the scope of its work it was hired to do. It was not hired to stay and guard this trench that it was hired to create, where Bob's asphalt was supposed to come in a day or two later. And to that point, there's no evidence in this record that Red Oak, in their contracting with Westfield, required Westfield to directly reach out to Red Oak and let it know when it left the site. And importantly,
were they required by contract to either remedy, to complete the job? Was it complete by Westfield's?
Yes, that was.
By not filling in their part was, right? Because you're saying Bob's asphalt.
Yes.
Was the contract, did the contract anticipate or require warnings?
No, there's no evidence of that. And additionally, as this court has said, not only in Hill, but I may butcher the name, but Renecki, there's no duty to warn of a risk in which the person is aware. The record is extremely clear that the plaintiff was aware. She took copious notes. She knew that Westfield, when they were on site, was doing the concrete demolition work and that the trench was left there. And additionally...
Counselor, I'm trying to get at the sort of nature of the hazard versus the timing of the contract, right? So here we have, you know, the hazard that exists, and there's some distance in days between when Westfield left and when this occurred. So if Westfield had made a giant 10-foot crater, and that was the job they were contracted to do, and they left it, and 10 minutes later someone fell in the crater, is that covered? And is the difference the nature of the hazard, or is the difference the timing, that it's right after it versus 9 days later?
Well, respectfully, those aren't the facts in this case.
I know. Well,
and also,
in my hypothetical,
yeah.
is that survive summary judgment?
I believe that it goes to timing and what the parties contracted for. I mean, again, is this court really willing to take the position that and hold businesses and their representatives liable years, days? I mean, how far are we going to go? That's going to affect businesses throughout the state. I mean, in Hill, the subcontractor completed the scope of their work, delivery and installation, and was off the premises 4 years before plaintiff's injury. Here, it was 9 days.
Well,
So why-
in Hill was different. The danger was something that arguably pre-existed or didn't actually relate. It was a contractor installing a dryer, or I think a dryer, right? And it was a gas leak. So it wasn't like they had installed a dryer and had left razor blades all over the place and somebody did that, right? Like, it's a little different. They didn't create a new hazard. The hazard that happened existed, regardless of the fact that they could have prevented it, maybe, I think was more the plaintiff's claim in Hill. This, I view, is different. Why is this not different, that even if it had happened, would you agree that if it had happened when they were still on site, 5 minutes later, somebody suffered an injury?
I believe if they were still on site, we'd be looking at a different standard, and then also, yes, it would change. But respectfully, I do not think that this case is different from Hill, in that in Hill, the record showed that the plaintiff and her daughter had smelled gas, and they did nothing. And of course, this court, that's where I pulled the citation from. There's no duty to warn of which the person is aware. And additionally, this is a question of objective standard, obviously, a question of whether the contractor used due care and to not unreasonably endanger persons when they were on site. Here, the Westfield owner testified that it wasn't, he did not have to do it, but he took the act of moving the dumpster away so that the residents would not even have to encounter this trench. And by the way, I know that the parties and everyone's called it a trench this entire time. It was a 10-foot shallow, about 4 inches dugout for Bob's Asphalt to then come in and fill. And Westfield cannot control, and there's nothing in the record, what Bob's Asphalt does. And respectfully, I think that the plaintiff messed up by not pleading a tort claim against Red Oak, but that's not what happened here. And so Westfield should not be held liable simply because the plaintiff didn't correctly plead her claim. Thank you.
Actually, before we go, I just have a question for the plaintiff. Can you respond to this notion of Westfield basically doing its work, completing its job, and then leaving? What should they have done differently?
Thank you, Your Honor. So, Your Honor, I think this goes to the concept of reasonable care. I don't think that the contract has any relevance to the question at all. So the notion that the contract may not have called for Westveld. So first of all, this isn't a contract to create a trench. It's a contract to repair the trash disposal area and the concrete pad on which the dumpster sits. And in the process of doing that, certainly Red Oak didn't call for create a 10-foot long trench. That was a byproduct of the work that Westveld was doing. And so my argument, Your Honor, is that this is an aspect of the reasonable care that comes with the work that Westveld was doing. A jury gets to sit down, like in any negligence case, like a contract doesn't exist. A jury gets to sit down and say, okay, Westveld, you don't have an obligation in this world to ever do anything. But once you choose to act, once you decide, we're in the business of fixing concrete pads and digging trenches. Once you decide to do that, you have to do it with reasonable care. And so a jury could look at it and say reasonable care, just like, frankly, Randy Westveld acknowledges, reasonable care involves making sure that there's cones or that there's tape that guards an area. He says in his, I feel like there's some revisionist history going on right now because Randy Westveld testifies the reason he didn't put up tape and cones, it's not because he didn't think this was dangerous. He said, I moved the dumpster and so I didn't think anyone would have any reason to ever be in that area. Well, the problem is that when you're dealing with darkness and when you're dealing with trenches throughout this whole area, we might have infinite paths that lead to this dumpster, right? We might have that. We don't have infinite visibility by Ms. Bowerman when she's in the darkness. She doesn't know where those paths are. And so I think that this question of what did Westveld have to do relative to that trench once they left the site, that's a jury question just like in any negligence case that deals with the reasonableness standard of care.
Thank you, Counsel.
Thank you,
Thank you,
Mr.
Your Honor.
Desmond. Case will be submitted.